Margaret.
Okay, so it's a transition point, I think, about this narrower ground from Beckles, which is Justice Ginsburg's concurrence did say, I think this should be resolved based on just the fact that sawed-off shotgun's an enumerated offense. And as a practitioner, I think it's the rare case where I don't know how much influence it actually played, but where I think the Supreme Court for once was attuned to the realities in district courts around the country. And at the argument in Beckles, Michael Dreeben, Deputy Solicitor General, was practically begging the court, please, I'm telling you, we have hundreds of thousands of cases around the country, which is true. In our district alone, we probably had over 1,000 cases pending challenging this provision of the guidelines. Like, please do not decide this based on the sawed-off shotgun fact in this case. And I think many of us were pleasantly surprised that they actually did reach the real issue that courts and practitioners around the country were waiting for guidance on. So that is sort of a transition to the two cases that I want to talk about.
Right, because we're still waiting for an answer.
We're still waiting for an answer on Demaya. I'm going to get to that. But the two cases from this term I want to talk about, which are factually very different, but I think share something in common, which is the opposite of Beckles, which is, I think, the often lack of appreciation by the court of coming up with rules that will be useful to district courts and to practitioners around the country. And those two cases are Pena-Rodriguez and J. Lee versus United States. So Pena-Rodriguez is a jury bias case. Most states and the federal rules of evidence have a rule that the court refers to in Pena-Rodriguez as the no impeachment rule. It's basically a rule of evidence that says that no evidence is to ever be taken, essentially, about the internal deliberations of a jury, and jurors cannot be made to testify about what happens in the jury room. So Pena-Rodriguez involved a Mexican immigrant defendant in Colorado who had been charged with sexually assaulting two minor girls in a restroom, I think at a sports stadium or something, a public restroom. And after he was convicted, and after the trial was over, two of the jurors came forward to the defense lawyer to say, you know, we don't know what to make of this, but we just think you should know that during deliberations, one of the jurors repeatedly made racial comments about the fact that the defendant was Mexican. This is, all Mexicans treat women this way. Mexicans have no respect for women. That he believed the defendant was illegal, and therefore, I guess his testimony and some other aspects of the case couldn't be believed because of that. So initially, the case the defendant had lost his challenge to his conviction because of this no impeachment rule, basically, that once things that are said during deliberations cannot be the subject of a challenge brought to a conviction. And underlying this no impeachment rule is the idea both that there has to be a very high bar of secrecy around jury deliberations, and also I think the idea underlying that we sort of take jurors as we find them, and that barring some outside influence that's brought to bear during the trial, someone trying to bribe a juror or threaten them, that this is the essence of the jury system. We're going to collect people from the community. We take them as we find them, their life experience and their own sort of common sense, and whatever's teased out during voir dire is the end of it, and then it's 12 citizens in a room together in secret. What the court did in Pena-Rodriguez is to say, well, we hear you on this no impeachment rule and its long history, but we think that racial animus is different and is fundamentally different and should be in the view of the majority, the one thing that can overcome the no impeachment rule. And where there's credible evidence that racial animus was, quote, a significant motivating factor in a juror's vote to convict, that will be the one exception. So to me, Pena-Rodriguez is the first illustration of what this case and Lee versus United States have in common, which is a result that might seem right on the facts of this case, which is the facts are very troubling, but that produces a rule that, in my view, as a practitioner, will be all but impossible to administer. And I think in Justice Alito's dissent in opinion highlights really this very difficulty and the questionable grounds on which the majority tries to distinguish racial animus as a special kind of bias. And I think he's right that it's not at all clear to me how racial animus is so different from a deep-seated gender bias or religious animus, or even extending farther than that, a deep-seated animus towards law enforcement or against certain kinds of criminal defendants based on the nature of the crime. So I think that the court seems confident that this is a little tweak, and I'm not so confident. To me, I think, I agree with Justice Alito that this case is basically the beginning of the end of the no impeachment rule.
Is this case not son of Batson?
Yes.
It is son of Batson,
Yeah.
but
and
I
Batson,
think...
Batson opened up, too, to the other kinds of equal protection categories,
Yes.
but it didn't open up to no more peremptories. It didn't,
Right.
So that may be the line that
And
that
I mean,
happens.
the thing that I think is a little different, and may remain to be seen in practice, right, is that because Batson is limited to one moment in the
Yeah.
criminal trial process, that even as it's expanded to other gender bias and other sort of ethnic and or even age bias in jury selection, because it's time limited, it's about things that happen within a couple of hours or at most a couple of days in a process that then is over. My concern here is that I think, I'm interested in what Josh thinks from a defense lawyer's perspective, but it's going to be very, we already have little bits of this come up in a lot of criminal cases after the verdict, where a lawyer will say, well, I was told by one of the court security officers that they thought they heard jurors ask this, or I found out later the jurors wanted to be escorted out of the courthouse after the verdict, and I think that maybe that reflects the fact that their impression of the defendant's family in the courtroom. And so I think now, if this is a basis to bring a challenge to a conviction after the verdict, that it really, I think, puts defense lawyers sort of, how much do you feel you now have to pursue this?
It will certainly increase litigation, at least at the threshold. And what I mean by at the threshold is most jurisdictions, including probably this jurisdiction, because of the way the opinion is worded, when they say that the attorney with the assistance of the court.
Right, they
because
did go
most,
to the
most,
yeah,
most jurisdictions,
the
like for
court.
example, the Southern District has a rule, the Second Circuit has a rule. It's really a circuit-made rule, but there are local rules as well that are less precise, but that you basically can't engage with a juror after a case without court permission. Now, this is asymmetrical. After an acquittal, the government doesn't have an ability to go back and sort of redo a case. What they do is impanel a grand jury and look for, if there's a corrupt basis for the acquittal, they can prosecute for that, and they did it in a Gotti case years ago. So it's really asymmetrical in the sense it's really a defense problem. But anyway, so if I'm approached by a juror, I have to go to the judge and ask permission to interview the juror and to then develop that. Or if I hear it from a third party, like Margaret said, you hear something that someone said and you want to pursue it with the jury, you have to get the court's permission. I think there'll be a lot of litigation on that threshold level of going to judges, seeking that.
Is there enough here?
Right.
I should be allowed to pursue it.
Right, but it also obviously will open up opportunities to do it, because heretofore there was really a blanket categorical prohibition on it. So here you can maneuver to, and I think Judge Lynch is right too, not only with respect to race, but say why not all legally protected classes? Why would they not be covered the same way as Batson? And in terms of Batson, I think that's a tactical aspect of it. On a strategic level, I think we'll have two salutary impact. The salutary impact will be in two ways in the sort of practical conduct of voir dire. One is that it will provide an incentive for prosecutors to have more diverse juries, not to get involved in sort of, what we would
Borderline
consider
Batson things.
Yeah, exactly. Disguised Batson problems, because a diverse jury would not have this kind of conversation. Because when you introduce a minority member to a jury or a gender or whatever it is, people don't talk out like that. They only speak out like that in homogeneous juries. So for prosecutors, if they want to avoid that, they'll have more, and I will take a more diverse jury over the prospect of this offhand comment by someone who's already lied in voir dire. And the same thing with voir dire in terms of a more searching voir dire to get at people whose biases might come out in deliberation that could contaminate a conviction. That prosecutors should be more tolerant of the more searching voir dire that we want, because we want to get at people's biases. So I think it will have that double effect in a practical level as the cases move on in order to avoid all this post-trial litigation.
So the second case, which is factually very different, but I think is similar to Peña-Rodriguez in the sense of sort of a fight between the benefit of categorical rules versus requiring a searching factual analysis in every case. And that's Jaley versus United States, which is a sort of follow-on or an heir to a Supreme Court case from a number of years ago, Padilla versus United States, which goes to a criminal defense lawyer's obligation to ensure that a defendant who's at risk for deportation or other kinds of adverse immigration consequences is appropriately and correctly advised about the consequences of a guilty plea for their immigration status. So here, Jaley was a childhood immigrant from Korea. He never became a U.S. citizen. He had a relatively minor drug conviction, and it was conceded in the case that the lawyer had wrongly advised him at the time of the plea. I told him, listen, with your situation, you're never going to be deported. It's not an issue. At the plea allocution, the judge, as required by Padilla, informed the defendant that, you understand, sir, right, that you're not a United States citizen, and it is possible that your conviction could lead to your deportation. Do you understand that? And apparently in this case, at that moment, the defendant said, I don't understand, and the lawyer leans over and says, as standard, they say that to everyone, don't worry about it, it's not gonna apply to you. So it's unlike a lot of the post-Padilla litigation that I've seen, the facts here are pretty egregious on the ineffective assistance prong of Strickland. And really all the action in Lee comes down to what does it mean to be prejudiced by that here conceded ineffective assistance on the substance. So prior to this case, there had been some debate among the appellate courts about, in the context of a guilty plea, what does prejudice mean? If you get bad advice for a guilty plea, what do you as a defendant have to show? And some courts have said, well, you just have to show that you would have gone to trial, that you would not have pled guilty, you would have gone to trial. And other courts had said, no, you have to show that the outcome would have been different for you. It's not enough to show that you would have elected to go to trial. You have to show that you had some reasonable prospect of, at the end of it, whatever path you chose, the outcome would have been different. And here, everyone conceded that the proof against Lee was overwhelming, and the chances that he would have prevailed at trial were minuscule, if even that. And so the Sixth Circuit had said for Lee that it doesn't matter what the test is, because either test produces the same result. Because here, no rational defendant, he had been offered a very favorable plea deal in terms of prison time, that no rational defendant would have chosen to go to trial against this evidence and face a substantial prison term. And so the issue before the court was, is it ever rational for a non-citizen defendant to choose a trial when they face the prospect of much greater prison time, but some chance, however small, of acquittal, which would avoid their deportation? So, the Justice Roberts wrote the opinion here and said that the test is that the defendant would not have pled and would have gone to trial, but shifts the focus away from an inquiry into the outcome, so the outcome isn't important. The mere fact of being able to exercise your right to trial, regardless of the likely outcome or even the almost foreordained outcome in this case, it's not about the outcome. It's about your right to choose your right to a jury trial, and that a defendant should be able to assess his own situation, make a subjective determination of what matters most to me as an individual person, and then choose that. And so what the court says is, well, a rule isn't appropriate here, and district courts should make an assessment when dealing with the 2255 on these kinds of facts. A case-by-case examination is appropriate, not a categorical rule. And again, Alito dissents, as in the Pena-Rodriguez case, primarily on this point that this is completely unworkable. And we're putting district courts in a nearly impossible position, and the resources that will be expended to have a case-by-case determination of the subjective desires of a defendant maybe 4, 8, 12, 15 years earlier is an impossible task to place on district courts when weighed against the cost, which in this case was the benefit of a finality, the finality of criminal convictions and a decision to plead guilty. So even though these cases are extremely different factually, to me, they both are clear examples, I think, of the Supreme Court, going back to Rory's point, in this term in particular, of wanting narrow grounds for decision, but ending up by tossing out some categorical rules, creating a situation where I think on the ground, practitioners and the district courts, it's going to be a real struggle, I think, for years to come to figure out what these cases mean in the context of the cases that are actually going to come in the real world.
Let me just say two things about the Lee case. One, Lee made a pretty good argument that if he had had Josh Stratel as his lawyer, it's not that he would have been acquitted by an irrational jury who engaged in jury nullification and gone to trial. It's that they would have negotiated a plea to a non-deportable, non-removable offense. I think there was some validity in that, and the court is actually very careful in a footnote to say, we're not deciding whether that would work or not, which is a good example, Margaret, I think, of this court not being able to agree on certain issues, and so they hit it off with a footnote. The other thing that's interesting about the Lee case is that Lee got a 1-year sentence, and if he'd gone to trial and been convicted, he would have gotten at least a 5-year sentence.
Instead, been in immigration detention all this time.
Right. Instead of agreeing, okay, I'll take my 1 year and then I'll be deported back to Korea and then sneak back in. Sorry. I'll stay in immigration detention for 6 years waiting for this case to be resolved. So the idea that he would not have chosen to go to trial even with no chance of acquittal is really, in some sense, disproven by his decision to stay in jail for 6 years.
It's one of the things, though, that is, I think, in the direction of Margaret's point. So what if it was a guy who was just a little different? You know, what if it was a guy who had who had some connections to Korea and hadn't been here for quite all of his life and wasn't in immigration detention at the moment because he'd gotten bailed and is now making the argument after having, taken the plea and gotten the 1 year and, to say, oh, well, I cared just as much as Mr. Lee did. And that's what the hearing is going to be about, is what are the subjective motivations of these folks? Would they have chosen, is there any reasonable possibility they would have chosen to go to trial? But that's where we are.
And there's a reason why I think there's a reason why a lot of these rules are in place that say, well, it doesn't matter what, it's saying. You see the same thing in the Fourth Amendment suppression context, that it's not a good idea to get into what are the subjective motivations of the police officers in question. We're going to have bright line rules that say, well, what would an objective person have done in this situation? And there's a reason for that, because I think courts are just not very good at figuring out what's in people's minds and what was really motivating someone. And when you create a situation, and both these cases do, I think, where asking courts to make an inquiry into the subjective motivations, whether of a defendant choosing to plead guilty or what motivated a juror's vote for conviction, those are hard. I mean, they're really hard questions, and to do so, in many cases, years after the fact, when people have very different incentives than they had at the time the events were occurring, it is a very, very challenging task that I think my sense is that the Supreme Court majorities in those cases failed to fully appreciate.
So
how difficult that test is.
Draytel has 10 minutes and I'll have 1. Because we're going to have audience questions.
Okay, so just to respond to Margaret for a second, is I see this case really more about a recognition of the importance of collateral consequences in the criminal justice system now. It's an ancillary part of every practice. I had a case in New York State where my client got a ACD, an adjournment in contemplation of dismissal, meaning in 6 months, if you don't get in trouble, the case is dismissed. That barred her from the financial industry because the FDIC considered that not a favorable outcome, consistent with a guilty plea, essentially. We went back, got the dismissal vacated so she could plead to a violation that is generic in its scope, so that now she's not barred from, so the navigation of these things has become so important. I think this case, to some extent result-oriented, is a recognition of those things are sometimes more important than the conviction itself in many respects. The other part of it is that I don't think deciding what would happen at trial is appropriate in this context. Trials are their own organic organism, in the sense that I couldn't tell you in the sense of what's going to happen on a cross-examination, what's going to happen with whether evidence comes in or doesn't come in. And so to say that a jury would have convicted that the evidence is overwhelming, I think, is a superficial analysis by any court to say that without going through the trial. That's what trials are about. So now I'm going to talk about 2 cases from this term and then one that's coming up. So the first one I want to talk about is McWilliams v. Dunn. And I'll go through these quickly so I can adhere to our time constraints. But just to give you a sense of this case, and again, for me, they're not so much about what the cases are in terms of holdings, but what they portend in the sense of what's happening in the criminal justice system, what's going to happen as a result of these decisions. But this is a capital case, and it's just start out. The opinion from Justice Breyer starts out, 31 years ago, petitioner James Edmund McWilliams, Jr. was convicted of capital murder by an Alabama jury and sentenced to death. 31 years. And if you think about, and the other capital case, Buck v. Davis, which Rory alluded to, is a 22-year-old case, a 1995 murder. And these are cases in which the Supreme Court has finally concluded that there was an error of such magnitude that a capital verdict that's 3 decades old is invalid. And the reason I mention that in that context is that's a very, very high hurdle to overcome. If you look at the pages where Rory talks about the orders without opinions, many of those dissents from the denial of certiorari are capital cases, where judges like Justice Sotomayor, where she's outraged that the court is not going to consider a miscarriage of justice in a capital case where someone's going to get executed. So to think about what it takes to hang on for 31 years or 22 years for lawyers and defendants to pursue this litigation to finally get relief in cases that the Supreme Court, which rejects so many of these, believes is egregious, I think should have us reconsider the death penalty altogether in terms of as a lightning strike. And in one of these cases, I'll show you exactly what I mean by a lightning strike, in the sense that, you know, it's the arbitrariness of it.
You got to talk about Moore against Texas at all in this?
No.
There's another one
Yeah.
where the crime took place in another capital case. Crime took place in 1980. So 37 years later, the Supreme Court is deciding ultimately that the fellow was that the trial court did not apply the correct standard for mental disability in this case to decide whether he was too mentally disabled to be executed. But the thing that struck me, not only is it 37 years this fellow has been on death row, it was for, he wasn't the shooter, it was a felony murder case. Somebody else killed the clerk in a convenience store robbery that was so botched that they all ran away and didn't get any money. There's clearly no plan on anybody's part to shoot that unfortunate victim. And you think, like, that's a capital case? That's one of the handful of cases in the country, that people are going to be, somebody's going to be executed for. And of course, the shooter had long since pled out and everybody else is gone. And this guy is sitting on death row for 37 years litigating.
Yeah. So McWilliams is also a mental health case, and I'll just read you the basic principle in the case, which is that the state must, and there's a prior case, Achey versus Oklahoma from 1985, decided while this case, it was decided before this case was ultimately decided in the Alabama courts, but pretty much contemporaneous with the offense. but that the state must provide an indigent defendant with access to a mental health expert who is sufficiently available to the defense and independent from the prosecution to effectively assist in evaluation, preparation, and presentation of the defense. And what happened here is really, it's a timing issue because it's a late disclosure of a report that corroborated a neurological defense in a penalty phase. Not about the crime itself, but purely about the penalty phase, about the imposition of the death penalty itself. So in that context, the Supreme Court said that the whole concept of evaluation and preparation was impaired by the fact that the trial court failed to give the defense a continuance, because this is records that came from a state hospital and from a court-appointed expert, which was part of the procedural wrangle of the case from the dissenters, which is that the question presented was really a more precise question of whether or not the expert had to be independent of the prosecution or whether it had to be part of the defense team. So independent of the prosecution, a court-appointed expert would qualify, but would not be a member of the defense team. But instead of deciding the question presented, the court decided the broader issue only of whether or not this particular expert, who was a court-appointed expert and not aligned with the prosecution, that whether the defense was given the opportunity to present this expert in the penalty phase, and ultimately the court said no. But I think there are a couple other aspects of this that are important. Number one, for defense counsel, this was the defense. This is a preserved error. A good job done by the defense counsel, arguing vigorously for an adjournment, saying I can't do this without access to experts. Getting this stuff overnight or a day in advance is not sufficient for me. I can't argue this. I'm not a doctor, and so it highlights what defense counsel has to do in order to make the proper record, but also in the context of the judge's resistance to giving a continuance in this case is not something that is limited to capital cases or this case. And, you know, in court-appointed work, in indigent defense work, there is a resistance to spending taxpayer money on what judges may consider to be frivolous. But defense counsel, it's not frivolous in these situations. You have a population of inmates that's probably 50% mentally ill across the country. You have neuroscience now that is much more sophisticated. So when you talk about the incidence of traumatic brain injury among criminal defendants and what that means neurologically, both in an organic way, in a psychiatric way, in a psychological way, in the 31 years that have evolved, you have an extraordinarily different world, both technically and in the context of what the population of our prison system is and how it relates to providing adequate mental health resources to a defense, either in the context of pretrial for competency, trial for a defense, or for punishment purposes. And all of these are extraordinarily important. Okay, Buck v. Davis, this is the case that Rory talked about. This is the lightning strike case where a expert regularly testified in Texas courts in death penalty cases in the penalty phase that blacks were statistically more likely to be violent, and people were sentenced to death as a result. There were 6 cases. John Cornyn, when he was Attorney General of Texas, actually confessed error, and they vacated 5 of them. The 6th was Buck. They didn't vacate it because they said, no, the defense attorney put the expert on and elicited the question because it was in his report. It was found ineffective assistance. This is a completely result-oriented case. I agree with the dissent in that regard, but I think it's an important case for reasons of doing justice and not having someone be executed on the basis of something. Talk about a lightning strike where 5 people who get off death row for the same thing that this guy is on death row for. So now I'll move on to Carpenter, which is a case
Well
for
done,
next term.
well done.
Carpenter is a extraordinarily important case evolving from 2 cases. Jones, a GPS case about the Fourth Amendment in terms of what constitutes reasonable expectation of privacy.
And Carpenter is granted for this coming term. It is not a decision from this term.
And Riley, which is a cell phone search without a warrant. And this is Carpenter is cell site location information, and this has been percolating for a while. There are 2 en banc decisions from the 11th Circuit and the 4th Circuit that did not make it to cert, but this one from the 6th Circuit did make it. So the question is whether it requires just an order under the Stored Communications Act, something that's reasonably relevant to an investigation, or whether it requires a warrant based on probable cause. And the question will probably not resolve entirely, but will certainly implicate the vitality or the continued vitality and control of what is called the third-party doctrine. If you surrender information to a third party, such as your phone provider, do you then lose the expectation of privacy in it? There may not be a categorical answer. It may not say the third-party doctrine is jettisoned altogether. I talk to people who think that what we're going to have is some sort of hybrid where the third party, a win for the defendant, will not necessarily be categorical, but will be something to the effect of the third-party possession is merely one factor in a larger balancing test, including many factors. And so for different types of information, such as banking records, which is all other case on the third-party doctrine Miller, you may never get to see that as being considered private. But medical information or certain information that you have on accounts that you don't think are subject to general dissemination, but that you share with people because you have to in the digital world, but that you don't consider, and my example that I'll give you is medical information, leaving aside the privilege aspect, which I don't think ordinary people consider when they share medical information. Don't think of it in a legal context. But they share it with the doctor, they know it's going to go to the lab, they know it's going to go to the insurance company, they know it's shared with all these third parties, but they never for a second think it's not private. And so the expectation of privacy in certain information may have to be compartmentalized in the digital space to allow for some revision or relaxation of the third-party doctrine. So that's what we're going to see resolved in some respect. The other part, the sort of the 800-pound gorilla in the room, is the good faith doctrine, which could swallow up all of the merits. But the interesting thing about Carpenter, as opposed to the two en banc considerations in the Fourth Circuit and the 11th Circuit, is that this one, the only mention of the good faith doctrine is in the concurrence, and the majority opinion the controlling opinion does not rely on good faith, but purely on the third-party doctrine, going back to a 1979 Penn Register case, Smith v. Merrill.
And by the way, we learned at lunch that you could do an entire panel on Carpenter and the implications of this. This is going to be one of the biggest Fourth Amendment cases I think you've seen in a long time.
Yeah, I mean, I think it is,
But we have 15 minutes for questions, so you get the last word right now.
Well, I think one of the most interesting things about Carpenter is how much weight should be given to the role of technology in our lives and whether that changes people's understanding of what's private and what's not. And maybe, I think you can make arguments in either direction, right? That we now share so much about our lives with technology company providers of various sorts that, embedded in a lot of Fourth Amendment laws, this sense, well, how do we know what the Fourth Amendment protects? We should ask, what is society prepared to recognize as private? What kinds of spaces do most people in our society view as private? What kind of relationships could give rise to privacy protections against the government? So this question of how technology is changing our perception of what is private and what is not, I think potentially could play a huge role in how Carpenter turns out. And I do think there's arguments to be made on either side.
Jerry, you look like you might want to say something.
No,
Okay.
let's take some questions, because we go on forever.
So
if I
let me.
start talking.
So my 10 minutes will be spent on nothing. I will say this: look at the Ziegler case, which is a civil case involving Bivens causes of action on page 33, where the court really revises what I think a lot of people understood to be the appropriate analysis for Bivens causes of actions. And it's in a remarkable context, which is the federal response of detaining hundreds of people right after September 11th, 2001. The allegation is detained on ethnicity and race, and then held in very unusual, harsh conditions, and then physically abused in those detention centers. And that they should have some independent constitutional cause of action, because the normal civil rights actions only apply to state officials. These are federal officials. And the court dials it all the way back, leaves one claim still in place for remand against the wardens of the MDC. And if there's one little tiny insider baseball part of this, it's that Justice Thomas, who concurs in the result, which dismisses these charges, says, oh, by the way, I think our entire qualified immunity doctrine is open to question because it's not supported by common law, and I'd be open to revising the entire qualified immunity doctrine. That's big news as well, if it goes anywhere, and it may not. The judge may be right. It's possible. We should take questions from the audience unless there are none.
I will say, though, that again, that's one guy. The thing that is a lot of them, if not all of them, in Ziegler, is Bivens is dead as far as any extension. Bivens is now, I think, essentially a doctrine that says we really can't have a situation where if a state cop and a federal cop jointly rough somebody up on the street, the state cop can be sued for damages under 1983 and the federal officer can't. I think that survives, that will survive. No one's tried to dial that back, maybe Justice Thomas, no one's really trying to dial that back. But any extension, any notion that you have a cause of action against federal officials that has not already been recognized by the Supreme Court, good luck with that one, because it ain't going anywhere in the current Supreme Court.
Well, right. And if you think Justice Kennedy is the guy with the finger in the dike holding back the torrent, Justice Kennedy says in his opinion two things. One, it's possible that the result in Bivens and the two Bivens follow-ons would have come out differently if we applied our analysis today to those cases.
Yes.
So that, and then he says, oh, by the way, we don't mean to suggest that those cases are wrong.
Because for the practical reason I said,
Right.
that's going to stay.
But if he retires and somebody is in the White House who will appoint somebody who's got a different point of view, I mean, suddenly Thomas becomes, the controlling Kennedy of the court. Okay, that's enough.
We've covered
Will you please applaud my panelists?